NACDL is the association of the nation's criminal defense bar.
Good afternoon. I'm Jumana Musa. I am the director of the Fourth Amendment Center at the National Association of Criminal Defense Lawyers, and we welcome you today to our webinar titled Surveilled Without a Trace, Challenging Digital Evidence Obtained Through RoundUp and Torrential Downpour in Criminal Cases. So the government, in the context of looking at cases of sexual assault online, has been employing unproven software to investigate peer-to-peer file sharing networks and other methods of trying to reach into people's computers and understand whether or not they're actually downloading pictures that can be designated as child pornography. And so today we're going to look at what those tools are, how do they work or how do they not work, and how you can challenge them in criminal cases. The webinar is going to feature Mohammed Hammoudi, who's the Assistant Federal Defender for the Western District of Washington, Jeff Fishback, who's the founder and president of Second Wave Information Systems, and Robert Hertz, the owner of the Law Offices of Robert Hertz. After the presentations, we will have plenty of time for Q&A, and we will also be flashing the CLE code on the screen. So I would like to turn it over to Mohammed.
Good morning here on the Pacific coast here. I'm in Seattle. I hope everyone's doing well despite the circumstances and the pandemic. I know a lot of people are stressed and clients are stressed, so my thoughts are with you. This is a condensed version of a presentation I would ordinarily do over about an hour. So what I want to do is talk about, as an attorney, if you're going to get a case that involves peer-to-peer issues, how you want to approach that case out of the gates. When you get a case that involves the possession, distribution, or production of images containing children engaged in sexually explicit conduct, the first thing you want to do is look at the affidavit for the search warrant. In the affidavit, what you're going to find is that there's going to be some vague language about law enforcement using either a surveillance technique or a technique to conduct undercover surveillance of the individual's computer, the target IP address. And then what you'll see also is that a summons was searched out, the IP address matches a particular home, residence, and then they execute the search warrant. And where you find yourself ordinarily is that the individual that's arrested either confesses to possessing or receiving the images, or what will happen is that they will not make a statement at the scene. And then the next step is that they conduct a forensic examination at the scene. And if they find images, they find peer-to-peer software on the computer, they will arrest the client. And then they'll do a deeper forensic examination of the computer back at the forensics lab. So the first issue is that the affidavit does not tell a candid story of what happened before this IP address was identified. What we've come to learn over the past 2 or 3 years over extensive litigation is that it's actually a complex process that has been put in place. The process is based on a software and a series of software that are developed out of the University of Amherst in Massachusetts by computer scientists. Those computer scientists work with law enforcement of the Pennsylvania State Police and the FBI to distribute the software to local police departments. This suite of software is available for access by your local law enforcement agencies on an online tool that is provided to them, where they receive updates to the software, they receive manuals, and they can basically get tech support. The peer-to-peer software is basically part of a larger system, and this system has been developed by law enforcement. And when I say law enforcement, I include the individuals at Amherst College, I include the individuals at Pennsylvania State Police, to collect and create databases to analyze individuals' activities on the peer-to-peer platform. Now, these databases contain two sources of information. One source of information that they contain hash values for all images and even text stories and videos and movies that law enforcement suspect involve images of children engaged in sexually explicit conduct. Now, the key word there is suspect. They do not know, in fact, whether they do, but because there's a lot of different standards that are applied for entering, particular image or particular text or something into this database. We have 50 jurisdictions in this country. Each jurisdiction has its own obscenity laws. The second thing they have is a database of IP addresses. And these IP addresses basically go back several years, and they keep track of which IP addresses are accessing these hash values over a period of time. It allows law enforcement, when they're conducting investigation, to see if the target IP address has engaged in long-term activity on the peer-to-peer network. And the reason that's important for law enforcement is that seeing activity over a long period of time, it basically gives them a retrospective analysis, a retrospective opportunity to see surveillance that they could have conducted in real time, and to focus on a particular individual as opposed to somebody who is on the peer-to-peer network and accidentally or inadvertently accesses images of children engaged in sexually explicit conduct. Well, that particular aspect of the law enforcement network, the law enforcement software, we've been contending raises serious Fourth Amendment problems in two regards. One, it's a database that is being kept by law enforcement to allow retrospective analysis of an individual's behavior on a network, and that database is not regulated by Congress. It's not like the APHIS database. It's not like the NIBIN database. There's no rules or law that regulates it. It's basically maintained by a group of individuals who are unaccountable to themselves and nobody else. So that raises one set of Fourth Amendment problems. The second set of Fourth Amendment problems is that it also allows for a retrospective analysis of behavior on the network. We can tell by looking at somebody's conduct over a long period of time on the peer-to-peer servers as to what kind of a person they are, what kind of images they like to look at. And the problem is that a lot of the images are not necessarily images of children engaged in sexually explicit conduct. Some of the images are too close to call. Some of the images are actually appear to be children, but actually are in fact not children. So what law enforcement is doing is maintaining a database of behavior on a network and analyzing that behavior. And a lot of affidavits that you will read says, and in my training and experience, somebody who uses this database has a particular interest in children, a particular interest in this type of activities, and you need to understand that that premise is drawn from this long-term analysis of this database, and so that creates another set of another set of Fourth Amendment issues that needs to be addressed. The third aspect of the law enforcement software and network that raises concerns is that I have recently, with an expert I've been working with, been able to discover that the law enforcement software actually is, in our position, is trespassing into the computer of the user IP address and changing settings. We have asked repeatedly for the copy of the software to demonstrate that it does in fact do this, and we've not been able to get a copy of the software to do that. The government will never give up a copy of the software. If you're ever able to obtain a copy of the software and access to the computer servers, they will dismiss the case. That's because the cost of disclosing this information is too high, and they're willing to let that one case go to avoid that cost. So we've asked access not only to the software, but also to the network and the server network that allows them to basically conduct the searches the way they are able to do so. The other aspect of a pretrial litigation that I would like to talk about is discovery. And it's important to hire an expert to educate the judge about this software. Jeff understands the technology very well. Terry Lehman understands the technology very well, and and good experts like Jeff and Terry will break down what the technology is in layman terms for the judges. And say, look, you want me to do my job. I need to, the defense lawyers asked me to do X, Y, and Z. In order for me to do X, Y, and Z, I'm going to need access to this information. And at least in the Ninth Circuit, it's black letter law that once the declaration is provided by the expert and it's material to something that is to your pretrial issue or it's material to your defense, then what you need to do is that you need to provide the software to the defense. That issue has been tested once in the Ninth Circuit in United States versus Budziak. I don't have the site handy, but you can easily find it with a Westlaw search. And the court said that the district court abused its discretion in not disclosing the software. Those are pretrial related matters. With respect to trial related matters, the way you want to think about this is that the government has to establish that your client knowingly possessed these files, knowingly received these files, and knowingly distributed these files. If there is not a confession in the case, it becomes very difficult to demonstrate that for the government. And understanding this software is critically important in generating reasonable doubt about whether, in fact, knowing possession, knowing distribution, and knowing receipt occurred. With respect to receipt, strike that. With respect to distribution, the government has to establish that they receive the files that are on your client's computer. Well, sometimes when they'll come to your client's residence, the files no longer exist. So what they'll do is they'll say, well, our software establishes that that we received the file from this individual based on an IP address connection and based on the fact that there was a handshake between our IP address and the resident's IP address, and the file was received by us. That if that's the theory of the government's case, that leaves them open to litigation to get a copy of the software. Because the other problem with the software is that it's never been subjected to a thorough validation testing. Any kind of software of this scale that is used in commercial platforms is subject to thorough validation testing, and it's subject to continuous testing. This software is not. So the other aspect of litigation is that, well, you say, like anything we talk about, this is basically the software is a process. Remember, although the software operates in an automated way, it was written by human beings, and human beings have flaws. And you want to be able to see who that code writer was, what bias he has, and look at the source code and be able to say, well, you say your software operates in this manner, and you usually get these declarations where they attest that this is a single source download. This software operates reliably. Well, these are all assumptions, and they need to be tested. You need to file a Daubert motion. You need to ask for a copy of the software. You can again provide a declaration from your expert, and your expert will say, well, I can do the software testing. I can test it in safe mode where it's not connecting or distributing contraband to anybody, and see whether what the government claims this software does in fact happens. Again, the government will not give up the software or access to the network in order for anybody to conduct this testing. They have conducted one set of validation tests only on single source downloading on an old version of one of the softwares, which was the peer-to-peer software of RoundUp some years ago, but nothing else, to my knowledge, has been subject to validation testing. So what we're left with is pretty straightforward. We have an unaccountable technology run by a group of individuals who are essentially answerable to no one. We have a software that has not been subject to validation testing. We're talking about massive amounts of information that they've been collecting on the network, and this is just the tip of the iceberg. The same individuals that developed this software and developed the network that I'm talking about also helped develop the network investigation technique that was used in the NIT cases that my colleague Colin Feynman and I worked on some time ago. So there's more technology that is used by this team. A lot of people just don't know about it. And it is very important for defense attorneys not to take for granted these cases and take what these affidavits and these police reports are saying at face value. We ran into this problem in other forensic practices, and we dug ourselves deep holes, and we're having serious problems digging ourselves out of it. This happened in fingerprints. This happened in tool mark examination. It happened with serology, and I can go on and on. And the problem is that there wasn't an aggressive attack at the outset, calling into question the reliability and the veracity of these claims and litigating them thoroughly, to do what we're supposed to do, keep the government honest and make sure they're not violating the Constitution and our clients' rights consequentially. And that's it.
All right, I think I'm picking it up from there.
You are picking it up from that. I was just about to give you a thank you. And I think now we're going to hear more about, because I think you raised exactly the point. They say, oh, we have the software. It works the way we say it does. Just don't worry about it. And you can't see it. There's trade secrets. There's all these reasons. And so I think it's important to get a sense of what you're going to tell Jeff is a little bit about how it does work or doesn't work, and where are the holes that we can poke into these cases.
Yeah, I'll kick off right from where Mohammed left off, at least where I think he left off, specifically with this term validation. That's the term that the government uses. It's a term. It's really a biased term. It's not an illegitimate technical term, but it's not an appropriate technical term for what the defense is asking for. Government continues to refer to validation because what they're doing is that they're validating that the software works a way that they state it works. And so far what they've given us, I don't know if Mo's gotten the same back, but what they've repeated to us is it works as we say in our handbook. We got a copy of the handbook, heavily redacted, and effectively it would be akin to me saying, my car only goes 100 miles and then it stops working. Well, yeah, we validated it. It's validated to go 100 miles. All they've done is they've validated the software works the way that they have established it should work, which Mo spoke a little bit about in terms of this single source. So one of the things that ends up happening when you're dealing with peer-to-peer is that a normal peer-to-peer session, the magic of it, the beauty of it, the reason that it was developed is that it allows you to get a large file or sets of files from multiple sources in pieces. So the idea is that where if you wanted to download, let's just say a 2-hour cinema quality movie, it might take you an hour, even with a high-speed connection, to download that file. If you were to download individual pieces simultaneously from 100 different sources, it'll take you a tiny fraction of that amount of time. So that's what it was developed for. It's a brilliant technology. It's a great use of the technology. And it wasn't developed specifically for the purposes, regardless of what I've heard a lot of cops testify to, it wasn't developed specifically for the purposes of moving child pornography or even adult pornography around. It's just a technology. It's a useful one. But what they're validating, typically when they talk about validation, it always seems to come back down to this single source. So what's significant about that is, and Mohammed hinted a little bit about this, I think he spoke a few minutes actually about it, that when you're challenging this case, what you've got is a matter of, did my client actually have the entire file? Did he actually distribute the entire file? Did he distribute a piece of the file? Did he receive a piece of the file? Because if he didn't get an entire usable file, then he doesn't knowingly possess. And if he didn't have the entire file, then he didn't really distribute. He might have distributed a tiny portion of it, but not a usable portion of it.
Hey, Jeff?
Yes.
We just have a question on some basic terminology. So you guys keep using the terms peer-to-peer and their network. And so someone's asking for just a simple beginner version of what does that mean?
Absolutely. So peer-to-peer is what I was just talking about. It's this notion of being able to move files between two different individuals. So normally when what all of us are used to, if we've all been using the internet, let's say, going back to the mid or late 90s or early 2000s, what you're used to is you go on to a website, Amazon or Google or something like that, and you download effectively your computer. You're not thinking about this, but you type something in, it's downloading a copy of something to your computer. Even though you consider it to be surfing, it's actually a download. What peer-to-peer does is it says, well, we don't really need Google, we don't need Amazon, we don't need anybody else. You can get that file directly from me, I can give that file directly to you. What peer-to-peer specializes in is this idea that if it's a popular file, then I have a copy and Robert has a copy and Wendy has a copy and Mohammed has a copy, and you can download an individual portion of that file from each of us simultaneously. The software handles it automatically. You don't have to do anything. And that would, in this circumstance, would make that file come 4 times faster. So that's peer-to-peer. One of the reasons peer-to-peer has been so popular with contraband is simply because if it's between 2 individuals, it's a lot easier to hold contraband than it would be to have Amazon delivering or to have Google delivering it. And Google obviously filters for that sort of thing. So that's why the government has been so interested in peer-to-peer now for quite a few years, because that's where it moves. So hopefully, Wendy, I hope that gives a basic primer on what that concept is. What ends up happening with this single source, which is really what torrential downpour is all about. That's its secret sauce. In fact, it was what they wanted to consider to be secret, is that it allegedly forces, it breaks BitTorrent. And that's the allegation that we've made, is that instead of where BitTorrent is just one piece of peer-to-peer software. There's a lot of different peer-to-peer software. BitTorrent happens to be the really popular one at the moment. What torrential downpour does is it forces, or at least allegedly forces, one download from one individual. So where my example was, I was going to simultaneously download a portion of the movie from Robert, from Mohammed, from Wendy. It's 3 times faster in that circumstance. If we add one more person into it, it's 4 times faster. The problem there is that what they're used to is hearing the defense come back and say, well, my client didn't distribute that file, because you can't even prove that they downloaded it entirely or at all from him. Maybe he had it, but that doesn't mean that he transmitted it, that anyone ever got a copy from him. With a single source, which is what torrential downpour is made to do, it allegedly forces the system to only download from one individual, so that they can say, our software, torrential downpour, downloaded entirely the whole file from your client. Therefore, your client had the entire file. And we know that because we validated our software, and our software works that way. And we're going to prove to you, because we have a copy of a document that says the FBI validated it and it worked. And where we get in this, again, piggybacks on what Mohammed was talking about, where we get into it is, okay, well, that's fine. So you're saying you validated a feature of the software, presuming that what we're going to argue is that our client didn't distribute the entire file. That's not necessarily what our argument is. And so more specifically in the case that Robert and I recently did, what the government wanted to know is, then what are you arguing so that we can test it? Tell us what it is that you're going to claim our software didn't do. We'll test for it and we'll tell you that it worked. Or presumably we'll tell you if it didn't work, but I don't think that was going to happen. And so what our argument was, well, that's defense privilege, and we can't tell you what we're testing for. It's a matter of what our client has told us is the circumstance. We want to test for it, but if we reveal that information to the government and we're wrong, then the government uses that against our client. So this comes down to a bit of client management, because if you have a case where your client has come to you and said, I don't know, I don't know, I didn't have this, I swear I didn't have it, I never downloaded it, if I did have it, I didn't know I had it, it wasn't me, whatever it wasn't me. That doesn't give us a whole lot that we can use in terms of materiality, because if we're going to get a copy of it, Mo, I agree with Mo 100%, minus the ability to force the government into letting us test it, we don't have a whole lot to go with in this. I mean, that has been what has gotten us the furthest, is this argument that we need to be able to test the software. Well, then the court wants to hear materiality. Robert will go more into that, but effectively for our purposes, what that came down to is, what is it that we need to do differently than what the government has done in its, again, air quotes, validation. And what we said is, well, everything. Our argument isn't about whether or not the government received a piece or the whole thing. That's not necessarily what we're looking for. Our client has given us an explanation of what he thinks happened, and the expert, me, has seen something that may match what he thinks happened, and therefore needs to test for that. So this is where some very careful client management comes into play, because if all your client is telling you is, I don't know, I just don't know, I don't know what happened, you really need to be able to go back and ask your client, well, is it possible that, did you see something on your computer that you thought was strange? Was your computer acting up in any way? You have to have something for your expert to grab onto to help form that declaration or affidavit to give you that materiality. So in our case, we had a client who was constantly saying, yeah, I saw weird things happening on my computer. I thought something was wrong on my computer. I thought something was acting up. And then we were fortunate that in the log files, we were able to see some things that looked like anomalies, which helped even more. But again, we didn't want to give the government all that information. We didn't want to give them our strategy. So this is where the declaration came in, and again, I think Robert will probably talk about what we had to maneuver with the judge in order to handle that directly with her, so that we weren't giving that information. Effectively, in our case, we ended up very, very lucky. We did actually receive a copy of the software. I can't honestly tell you that I've tested it because we had to agree not to, but the government in our case accidentally gave us a copy of the software. It was just produced in their validation results. We challenged it. The judge she appeared as though she really wanted to give the government an opportunity to demonstrate that they could give us what we wanted. The government, of course, was guessing at what we wanted because we weren't telling them what we were testing for. Similar to other cases, we were asked by the judge to attend a testing that the government would do in front of us, a validation. Government produced an entire validation with results in front of us, which they had to package up onto a thumb drive and send to Los Angeles for me to look at. And in the process of packaging it up, I was 100% certain that I saw their witness accidentally put a copy of the software on, as well as the results. So how much that bought us, I don't know, but it certainly was an interesting element to the case. One of the other things that I wanted to touch on that Mohammed was talking about was this history of what a client is doing, what a defendant is doing in terms of monitoring them. What we get in most cases, and this is something that you need to look for, generally speaking, the government's going to give us the last most significant log. So you're going to get a log file that the government considers to be the one that nabs your client. not necessarily months of log files. So I'm dealing with this in some other torrential downpour cases right now. It behooves you to ask the government what other log files exist that have your client's IP address in it. They know it, they have it. It's not going to be a surprise. It's not as though you're going to get something that is going to make things any worse for your client. They already know what matches your client's IP address. I've seen how the software works. It puts those together. But what it does for you, and this goes along the lines of what Mohammed was talking about, is that it allows you to go back and say, well, so you found this file, but as we had in our case, but you had months and months of looking at my client's computer and finding nothing. If you have to go to trial on this, that's going to be pretty significant with the jury, because one of the arguments when it comes to peer-to-peer is my client never saw it. My client put out a general search and something downloaded in the background, and the government saw that, and the government served a search warrant and came in and got my client. And that may or may not be the case, but one way of helping to demonstrate that that wasn't the case would be if the government was surveilling your client for a long period of time and didn't find anything during any of that. So it's an important thing. But I'll emphasize before I hand off to Robert, I know we may or may not go back and forth a little bit, but I'll emphasize that, at least in my opinion, it's really, really important to try to make this a pre-trial exercise. I've been doing this for about 25 years. Taking these things to trial tends not to be nearly as pretty as what you can get pre-trial, and you can get a lot pre-trial because, as Mohammed mentioned, once you get the government into a position where you've shown materiality, where your expert has demonstrated the need to test this software independently, the government doesn't want to. They don't want to continue on with this kind of case, not with this software. They don't want to give up the software, which leads me to believe that the software would not survive a test if we gave them one.
All right, so far it sounds like challenge early, challenge a lot. I think what nobody needed this webinar for was don't trust the government when they say trust us. It works just fine. And getting into the question of what some of this looks like when you try to ask for that software, when you try to actually test the software or figure out what's behind it. And so I know, Robert, you're going to talk a little more specifically about how that plays out when you're litigating a case. And so I'm happy to turn it over to you.
So good afternoon, everyone. Jeff and I worked on a case in the federal district up in Alaska, United States versus Matthew Schweer. I've provided quite a few documents related to that case that I believe have been provided to webinar participants. But I'll make reference to some of those. In that particular case, the case initiated was initiated in October of 2016. FBI agent up in Alaska initiated a peer-to-peer search, and this is very typical in cases like this. This is what he writes in his affidavit in support of the search warrant. He indicates on October 20, 2016, he doesn't even say he was the agent. He says an FBI agent working in an undercover capacity connected to a peer-to-peer file sharing program. He doesn't even name the program, which is very typical. In this case, the peer-to-peer file sharing program that he actually connected to was Torrential Downpour. He never once mentions that name in his affidavit anywhere. He indicates that that file sharing program was operating from an IP address that he describes, and from an internet connected computer in the Anchorage, Alaska office of the FBI. So essentially what he says is, sitting from his desk, he connected to Torrential Downpour, which I believe is ultimately stored at the National Criminal Justice Institute Training Center, and that's where that is where the servers are that host most of these peer-to-peer file sharing investigations. And he indicates that this peer-to-peer program identifies other computers on the network that are sharing images and video files of child pornography. The program identifies these files by comparing hash values previously identified as images and videos of child pornography with files with hash values of files being shared on the network. So what he's referencing now, and what Mo has alluded to and what Jeff has alluded to, is this database. And the database is known by the acronym ICAC-COPS. ICAC stands for Internet Crimes Against Children, and COPS is for, and that's the task force, the various task force located around the country locally. And COPS stands for Child Online Protection System. And that's the database they don't want to allow access to. Based on testimony by one of the program developers, Robert Erdley, who's is a detective from Pennsylvania Police and worked on designing the program with the University of Massachusetts at Amherst. According to him, he is the sole administrator in charge of that database, and he ultimately decides what images, what texts are uploaded to the database for investigation, and what hash values are uploaded to the database. As Mo indicated, some of those images are not child pornography, don't meet the definition of child pornography. They might meet the definition of child erotica. They might be images of children in bathing suits at the beach, or they may be other completely innocent images. And that's how, in the affidavit, it was described. And so we didn't discover really that they used torrential downpour until we got into the logs. Now, as Jeff indicated, sometimes they don't provide the very many logs, if any, or maybe just one. In our case, they produced thousands and thousands of pages of log files. And the log pages can be intimidating. They are basically, they begin with the FBI computer attempting to, as Mo called it, handshake with the target computer, and it notes the time, the IP addresses, and things of that sort. And then it starts providing hash value numbers, and it's very dense and can be difficult to read. And we got thousands and thousands of pages of it, and down in very small print, smaller than the log file print, was a reference to torrential downpour as the program that was being used. And that's how we learned that that was the program being used in our case. Prior to making a challenge to the torrential downpour software, I got Jeff on board early. We negotiated for a long period of time over how we were going to receive the forensic images of the client's digital media that were obtained with the search warrant, so that Jeff could do a preliminary analysis of in comparison to the FTK examination done by the FBI. And that allowed us to analyze what the government was saying they thought happened in this case, which gave us a foundation for making our claim for why we needed to obtain a copy of the software. So as Mo indicated, sort of the seminal case in the Ninth Circuit is Budziak. The citation there is 697 F 3rd 1105 Ninth Circuit 2012 case. The critical thing in Budziak is you have to be able to establish materiality. And in all of the cases I've come across where attorneys have tried to challenge torrential downpour and get a copy, almost universally when the courts deny the defense the opportunity to get a copy, it's because the defense failed to establish how the software would be material to a defense in the case. And that could be a difficult obstacle to overcome. In the cases where the courts have allowed some kind of examination, And in our case, it was really helpful where the downloads that were done, there were 4 different periods where the FBI in the Schwer case between October and November attempted to download from my client's computer what it thought were images of child pornography. They made multiple attempts, hence the thousands of pages of logs. And in every case except one where their software said the client had files and had images, they were unable to download anything. They only were able to download once. They got 2 files, and one of the files was not even child pornography. And then, based on those surreptitious surveillance of the client's computer, they went out and got the search warrant. They then came to the client's house, seized all his digital media, and did a forensic analysis of the digital media. And in this case, when they did that, none of the files that they claimed during their surreptitious searches the previous fall, none of those files and no fragments of those files were ever found on any of the client's digital media, including the image they said they downloaded. They couldn't find that on his digital media either. For us, that provided a really solid foundation to question whether the government software was working properly. And that gave us the core of our materiality argument. Our judge admittedly, on several occasions, admitted she had very limited understanding of computers. And so one of Jeff's chief jobs was to educate our judge in peer-to-peer networks and in torrential downpour and single source downloads and how BitTorrent works. In this case, torrential downpour is a FBI modified client. So BitTorrent is the network, a program that allows you to access that network is referred to as a client, and which should be distinguished from your clients. And so the client that my Mr. Schwer was using was called uTorrent, and the FBI had modified a uTorrent-like client in a couple of ways. One was they claimed they modified it so it would only do a single source download. In all other respects, the government claims it operates just like any other BitTorrent client. And that's never been tested. They will admit that there's never been any independent third-party testing of their software ever. Mr. Erdley, the detective from Pennsylvania, who testifies almost in all of these cases about torrential downpour, has indicated that the only test he's aware of was done by the FBI itself. He claims he does not have a copy of that and doesn't know how to get a copy of it. To my knowledge, that FBI test has never been disclosed in any litigation. And access to the ICAC COPS database has not yet occurred either. We didn't ask for access to that for any of our tests. We did not think we needed it. I do know that in the Gonzalez case in Arizona, and I provided some documents from that. There were 2 court orders in the Gonzalez case that I provided. They are now requesting access to ICAC COPS. The testing in Gonzalez was government testing supervised by the defense expert. In our case, we were actually able to get a court order that allowed independent third-party testing. If the government had ultimately provided us a copy for testing, it would have been the first time there was an independent third-party test on torrential downpour. Ultimately, they walked away from the case and dismissed the counts related to torrential downpour. But it took a long time to get there. Even after we got the initial order from the court saying that we had shown materiality and we were entitled to a copy of torrential downpour, the government then mounted a vigorous challenge to the manner in which torrential downpour would be provided to the defense, and essentially tried to limit the manner that we could test. And the way we characterized the way they were trying to limit us was that they were essentially trying to force us to replicate their validation. And we had to keep coming back to the court and saying they didn't want to give us internet access at the laboratory. They didn't want to give us access to any multiple ports. We were only allowed access to one port on the computer. There was a lot of technical wrangling that was entirely dependent on Jeff's expertise in order to convince the court that what the government was trying to do, while on the one hand saying they were going to give us an opportunity to test the software, they really didn't want us to test the software, and they were doing everything they could to limit the manner in which we were able to handle it and examine it. At one point, we were close to having a protocol approved by the court, and then several weeks later, the government came back and repudiated the protocol that had been forged for, probably nearly 4 or 5 months of litigation. They completely repudiated it and didn't want to engage in that at all. When the court said, no, we're not going to do that, the government finally decided they were not going to provide us a copy. They had actually sent a copy down to the RCFL in LA for examination, but ultimately wouldn't agree to allow us to access what they had sent down there. So we never actually got to examine the software, although we were in possession of it. We did get, as part of the litigation, we asked for copies of the user manuals. We ultimately got that, but that was heavily redacted. We asked for copies of change logs. Change logs are what the software writer keeps track of when they make changes. We had 2 different versions of Torrential Downpour used in our case, version 1.15 and version 1.23. I know at this point they're up to version 1.33 at least, if it's not been modified since. And so it's important to get the change logs that the software writer keeps track of to illustrate what bugs are in the software and what changes have been made. Erdley has testified repetitively that there's only one bug he's aware of and it was fixed, which is strains credulity, because in almost all software production, there are bugs, and many, not just one. And so you have to challenge these claims that are being made that there's only one bug. You've got to get the change logs. They initially testified that there were no change logs kept by the software writer at Amherst. Then they released some, but not all. And that litigation was ongoing at the point where the torrential downpour charges were dismissed. So we were also required to destroy our copies of the user manual and destroy our copies of the change logs as part of the litigation. So those couldn't be distributed to other defense attorneys. But what I can tell you is, if you can make your materiality argument and identify how the software appears not to have operated as advertised, your chances of getting an order that allows you to do some kind of testing is pretty good. Ultimately, the goal should be to do third-party independent testing, not supervised by the government, with no equipment being run by the government. In the Gonzalez case, the initial testing they did, the computer with the torrential downpour was completely operated by government agents, and there were government agents in the room. That was something we were not willing to tolerate in our case. And at the initial evidentiary hearing, we were not willing to disclose what our testing was going to be about and how we were going to do it. And so initially the court ruling was, well, I'm going to allow the government to do its validation test and you can observe it. And that's all I'm going to do, because I think that's sufficient based on what you've told me your concerns are. Interestingly, when the court finally issued a written ruling after that evidentiary hearing, because we claimed privilege during the hearing multiple times, the court finally relented smartly and said, by the way, I'll give you an opportunity to show me why your tests are material, and you can submit it in camera ex parte, which we did. And that ultimately drove the government just crazy because they wanted to know what we were going to do and how we were going to do it. And the court never, ever backed away from that. So we were able to convince the court through our ex parte filing, and by maintaining that everything we were doing was privileged, the court acceded to our request and gave us an opportunity to do completely third-party independent testing. And that's when the battle over, well, what are the ground rules going to be? What equipment gets used? What software gets used? Who gets to be in the room? How many days of testing do you get? And we litigated all of that. All of those materials should be in the all of those pleadings should be in the materials that are being handed out to the participants today, so you can see the course of litigation. But we never retreated from our position that it was privileged information. The Gonzalez case was litigated differently. They've basically been very open about what their testing's all about. And that's a strategy you can employ. That's not necessarily one I personally endorse. I think it's better to maintain privilege, as Jeff alluded. You know, if the testing doesn't go your way, you don't want that ultimately used against you, and your defense may change after you've done your testing. But that was how our litigation transpired, and ultimately we're now post torrential downpour charges. Those have been dismissed. At this point, we're now fighting over the images that were found on the client's computer, and 95% of them were thumbnails and unallocated space, which ultimately we believe is not going to be usable evidence by the government. And what's left now is a far less robust case that the government has. They're ultimately going to be limited to about 15 images of questionable use. So the pretrial litigation in this case, in Mr. Schweer's case, has really trimmed the government's sails, made this a much more defensible case than it otherwise would have been. And ultimately, if we have really high hopes that even during trial, we may end up with a straight up acquittal in this case. If not, certainly the consequences for the client for sentencing purposes are going to be far, far less severe because of all the pretrial litigation we engaged in this case. That's it.
Okay, and so we are starting to get questions, but I know that there is a lot that came up here. And one of them, just so we can get this out of the way, is what is the case name? Can you provide the case name?
For my case, Mr. Schweer's case? Yeah, it is United States of America versus Matthew Schweer. Schweer spelled SCHWIER. The case number is 3:17 CR 00095 SLG, and that's S as in Sierra, L as in Lima, G as in Gulf.
All right, I wanted to give you, Mohammed, and you, Jeff, the opportunity to weigh in on any of this, because I know Robert just gave sort of a detailed discussion of the pretrial work that's been done on this case and how it's gotten into this posture. But I don't know if that sort of brought up anything for either of you that you wanted to jump back in with.
Yeah, so that's what Robert's been able to accomplish is a casebook example of using what I call aggressive pretrial litigation to change the landscape of the government's prosecution and force the government into have to making choices about whether they want to proceed in a particular way or not. And I'm sure the charges that were dismissed were mandatory minimum counts, which makes it much harder for the government to have leverage over the client in extracting a plea. And now, everything has changed. I would only add that another example is having an expert involved. This is a good example of having somebody involved who helps Robert navigate the technology and helps educate the judge. But I would go through that litigation and see what he has done over the period of time to see how that litigation developed, the timing, and everything is very case specific. But that's what I have to add.
Actually, I want to build on what Mo was just talking about. One of the things that we found interesting, and I've been seeing this more and more in cases, there may be a reason to have two different experts, not necessarily to double the effort, but to use them differently. Because one of the things that Robert and I had to very carefully navigate around was, frankly, knowing too much. So at a certain point, I actually brought in a coder, not someone who's ever testified, but just someone that I trusted to physically attend, because we never knew that we, hopefully everybody's sort of smiling at this, we don't know that we wanted what we were asking for. In the end, if the government had just given in and given us everything we asked for, we don't know that it would have made our case any better. It might have ended everything for us. Only the client really knows, in all likelihood, what we were going to find. So from my standpoint, most of what I was doing in this case was this pretrial work. It was writing declarations and educating the judge, as Robert was talking about, that sort of thing. But had we been, we always sort of got cut short, but had we been given the opportunity to really do any real testing on our own, it probably would not have been wise to have that be me doing it, because that would have possibly ended my involvement in the rest of the case, my usefulness in the rest of the case, just from what I learned. Because once I've seen it and they know what I'm going to see, that really exposes me to some difficult cross-examination on the stand. So I just wanted to make sure to add that this is one of the circumstances I'm seeing it more and more, where it might pay to kind of bifurcate the job of an expert.
I think it's interesting we were talking about bifurcating experts, because you were also just bringing up, Jeff, having brought in a code specialist at some point. I think one of the things that people struggle with, and I know one of the things that we get questions about, is how do you even identify who is the expert you want? Do you want someone who can understand code and analyze code? Do you want somebody that can understand some other aspects of this? How do you even start with a question of, like, who is the expert, besides saying, well, it's me? What is the type of expert you're looking for? And maybe this is a question for you, Mohammed, or someone else. As you look at the case, as you start to run down the facts, what are the things that flag for you what type of expert you need to be engaging?
Because in this particular case, that was my call. I just wanted to give you my thinking on bringing in specifically a coding expert. He was brought in because he doesn't know litigation. That was the feature. I wanted somebody who would not be useful on the stand, period. I wanted somebody who could actually just take a look at it, answer some questions for me, and he was instructed that he was only to answer questions that could be answered the way that I was hoping they would turn out, and not to give me answers otherwise. But in that particular case, I just didn't want anybody who was going to be useful to make the case more complicated.
I think the way I would answer that question is that it's always tough to find a good expert for your particular case, especially when it's a novel issue. I remember once talking to an attorney I used to work with in San Francisco, Michael Burt, and he did a lot of litigation early on challenging forensic technology, serology, and a lot of times you had to work with the experts, and it was training on the job. At least with Terry Lehman, who I've worked with, who's our local computer expert up here, it was like that. I got a case about 4 years ago, and we took the case, and he treated it like a technological problem he had when he worked at Microsoft. He's presented with a project, and he looks at the project, he comes up with a plan, and he works through the problem, and then you learn. And then the important thing is, we share information. I really believe in the collaborative efforts of the defense bar, because we're so compartmentalized in our little regions, is that you want to create, bring national attention to it, and then other experts across the country will look at it and absorb information and be able to pick up the lead and do work, and other people like Robert and Jeff will do great work, and so I think it's just this was something that a lot of people didn't know about. But you want somebody with a technology background who understands computers, who understands basic technology, and can learn on the job. I think the harder part is, by the way, is to convince for public defenders to convince your bosses to get funding for it. So sometimes you need that. At least with Terry, what I've done is I've had Terry call my boss and talk to him about what he tends to do and why it's important, and then understand that once you do some of the work, you're not going to reinvent the wheel with a lot of the work the next time, because it's acquired knowledge, and once you acquire that knowledge, then you know it, and then you know where to build on it. So that's my advice about experts.
One secret when seeking out experts pre-budget, I have a few, I'm talking to other experts. I think this tends to work across the board for those of us who are actually doing this because we actually like what we do. If you can sell your case, if you can make the case something that is going to make a difference. Robert sold me on this case early on. I knew this was long before we had all of what has transpired. I knew this was going to be an interesting case. I knew that Robert was going to, if there was an opportunity, he was going to find a way to make precedent. And even if the money wasn't there, that's important career-wise, long-term. So sometimes you may be able to at least get some information from an expert that's useful, even before you've got a budget approved.
Thanks. And I'll just point out, we are flashing the CLE verification code. It is 7, the letter N, the number 4, 1, 2, 3. You should have received a form that you can fill that out and send it back, 7N4, 1, 2, 3. I will also say that this program today is free of charge, and it will be videotaped and up on our website later, but that is simply because the Fourth Amendment Center of NACDL is grant funded, and that is part of the terms of our grant, is that we're able to bring you this programming for free. I will also say that NACDL has just myriad other resources that are available to members. And so if you're not a member and you are considering it, if you do go and join today, you can get 15 months for the cost of a 12-month membership. It's nacdl.org/join. So you can feel free to check that out as well. And more importantly, what we do at the Fourth Amendment Center is we do gather these resources. We do these webinars, and we also give attorneys direct assistance in their cases. So the Gonzalez case, for example, is one that our litigator Mike Price worked on. We are available to you if you have questions on cases like this as well, to consult, to share materials. And you can reach us at the email of 4ac@nacdl.org. That's the number 4, the letters AC@nacdl.org, if this or other tech issues come up in your cases. I believe we've gotten to the end of our questions, but I would say to the three of you, if you have any information you would like to wrap up with, we would welcome that. I know this is complicated. I know it can be off-putting because you're talking about code and you're wondering if you can get to the code. And if you actually get to the code, will that help you? What do you know what to do with it? Do you know who to ask to think about what to do with it? What do you do if the government says we found this, we suspect this is on my client's computer and then there's nothing on the computer? It sounds very like sort of otherworldly, right? Where the government has somehow reached into someone's computer, said something is there, we're charging you with these serious crimes, and they use that to seize the computer, and then they don't find what they say they found, and sort of where do you go with all that? I think it is a tough nut to crack. It's very different from sort of a traditional criminal prosecution, where you have a piece of evidence that's tangible that they actually went and got from somewhere. So I would love if you guys could wrap up with any thoughts or advice as people encounter these kinds of issues going forward. Yeah,
I would just add that feel free to call me if you have questions. I have time. You can spitball your case issues with me. I'm at the Federal Public Defender's Office. You can look me up. It's my phone number is on the internet. And the other thing I would add is that most Fourth Amendment cases, landmark cases, were the most recent ones are technology-based cases, and it required people to challenge these issues and litigate them. And for many, many, many years, courts kept rejecting these challenges until they changed. So if you're not doing the work and you're not challenging, nothing's going to happen. So I would encourage you to fight these issues.
My advice would be, don't treat it like technology. Treat it like everything else. This really, while from my standpoint, I was utilizing or exploiting technology as part of my job, that I don't think, even though I think now Robert sounds, it's really neat to hear Robert talk because he sounds like an expert himself now. But that wasn't really a major part of what Robert and I were doing together. What we were doing was just understanding what were the areas that we could utilize in terms of how this piece of evidence, not necessarily technology, but how this piece of evidence fits into the constitutional responsibilities of the court and of the government. So the specifics, even though it's really interesting to talk about how it all works, they aren't really as important as simply understanding that it is something that has not been well tested, and the government should be held to that responsibility of testing it. And as long as you look at it from that standpoint, you don't have to have all the. Frankly, we got good fortune. I mean, I think we all know that part of doing well in a case is some luck. But even if we didn't have it, I think we still would have approached this very much the same way, which is that we had a client who said he didn't do this, and he gave us reasons that he said he didn't do it. And our point was that the government's, what they were telling us, made their software effectively witness. And I think that's an important thing we haven't talked about, which is that the government, when we talked about interviewing a witness, understanding a witness, they effectively represented the software as the witness. And so that was really what sort of kicked it all off, is if the software is our witness, then we need to be able to talk to it, to look at it, to see how it works. And so as long as you can find that hole and it exists, and I'll say the same thing as Mo said, always give me a call, whether you can get the budget or you can't get the budget. These are interesting issues. They need to be pushed. And even if a case can't afford it, what happens in Mo's case or what happens in somebody else's case always helps one of my cases. So we're kind of all together on this.
Thank you. Robert, do you have something you want to wrap up with?
Sure. So I join Jeff and Mo in their invitation. You can always contact me. My name, address, and phone number, email address are in the captions of the pleadings that are hopefully being handed out to the webinar participants. Jeff's right. I sound like an expert now. I'm not, and I certainly wasn't even close to that when this case first began. So I would encourage anyone who feels intimidated by this case, that feeling may be is perfectly legitimate when you first start out on the case, but don't shy away from learning the technology. It actually, when you've got someone like Jeff to work with, not only did Jeff educate the judge, Jeff educated me, and I needed that as much as the judge did. It's what allowed me to litigate effectively for my client, because I'm not a computer forensics expert. I'm just an attorney. And in fact, math was not even close to one of my best subjects. So it's learnable information. And I spent a lot of time reading briefs and articles. The ProPublica article that came out last April was a real good springboard for me. I looked at the case law, looked at Budziak and Crow and the cases that were not successful, like Morek, and just got educated. And it takes time, but it's very doable. The last thing I would say is and this goes to what Jeff was saying about the software being the witness. It is in fact Robert Erdely's claim that it's not a problem if after we seize your digital media, if we don't find the files, because our log files are the proof you possess the file. The fact that we were able, even if we didn't download a file, and this was their claim in one of their accounts that was dismissed, even though we didn't download a file from you, we got pieces of a file and we found file names, and it's all in our log, and our log proves you possessed it, even though we can't prove you possessed it by showing you an image that we found on your computer. That's a very, very dangerous claim. that's going to be the next big fight, because ultimately that's where the government's going. Even if they can't find the actual image on your computer, they're going to claim that you had it anyway. And that needs to be vigorously fought. Don't give up on these cases. Fight and fight hard. And at the end of the day, you're going to have a much different case if there's a case left at all. So good luck.
Thanks for that. And I'll say one of the reasons that we at the Fourth Amendment Center have been so interested in these cases is that we understand that once the government sort of, if they sort of go through that opening of saying, but we found it on your computer, we have enough files, we know it's there, even if we can't see the evidence or you can't see the evidence, these things always come about in cases that tend to make people back away, right? Like where they're charging someone with child sexual exploitation. It's the kind of thing that makes people want to step away and say, of course, we have to do whatever we need to do. But we also know that the government will take those tools and use them in all kinds of cases. And so it's really critical that we get good law established now. So I'll say again that the CLE verification code is on the screen, 7N4123. And we do have resources up on our webpage, which is also there, necdl.org/4AC. And if you have questions, we are also here to assist. 4AC@necdl.org. Thank you again for joining us today. And again, if you want to become a member, necdl.org/join. You get 15 months for the price of 12. I want to thank our guests for joining us today and giving us some really critical information on these practices that are currently being used by government and helping us understand that even though they call it technology, it's no different than any other scientific, and we use that term very loosely, test that the government has introduced in the past that has later been picked apart and shown to be completely ineffective. So, think of it as hair microscopy. Think about it as any of the other issues that have come up that have been held up as a science that was so determinative and later found out to be more farcical than science. So thanks very much.